Good morning. And first of all, let me thank you, the organizer, for including our paper on the program. And we surely learned a lot from the previous presentations. And this paper is co-authored with my two supervisors, Professor Denbo and Professor Ho from University of Edinburgh, and also Ross Levine from UC Berkeley. And we learned a lot from Ross, and hopefully we can improve the paper further. So legal institution is one of the most important determinants of financial markets development and also economic growth. And there are two broad strands of literature emphasizing this. First is that legal institutions promote financial markets development by enforcing property rights, providing private contract, also providing checks and balances on government expropriations. And this in turn promote economic growth. And the second strand of literature emphasizes the direct impact of legal institution on economic growth. Both of these literature say that legal institutions are very important. However, those legal institutions are defined by Western standards. So this may pose problems. For example, these law, finance, nexus may not apply to Eastern countries such as China, India, etc. Actually, Franklin Allen and Donald Clark and their co-authors find that in China, legal institution is not a driver of financial market development and economic growth. Instead, they are consequence. So from the World Bank, we also can observe that despite Chinese weak legal institution enforcement, China still got the second largest market capitalization of domestic listed firms in 2014. So all of this evidence substantiate that the law, finance nexus, commonly defined, won't apply to China. So in this paper, we ask three broad questions. First is that, does legal system promote finance in Eastern countries such as China? Why it does or why it doesn't? Why, despite their weak legal institutions, some Eastern countries can still grow at an enormous rate on their financial markets and economic growth? And we answer these questions by introducing and examining an alternative legal system and evidence from China. This alternative legal system is called Xinfang in China, and it is deeply embedded in Chinese culture and history. It can be traced back to 2,000 years BC. And Xinfang system is broadly defined as a mechanism for citizens to file complaints, resolve disputes, and also seek resolutions from government and its associations on higher administration level. I will further explain this, why it is so important to extract power from higher administrative level. We can see from here, the black line is the number of Xinfang cases, the blue line is the formal legal cases. We can see from the figure that the Xinfang system doesn't only exist, it has wide applications. In 2004, we observed that the number of Xinfang cases is more than twice than the number of legal cases filed. And although the number of Xinfang cases is decreasing over time, in 2012, yes, there are still 7 million cases filed in that single year. So there's also some distinctions between the formal legal system and the alternative one. One of those is that Xinfang system is more common law nature, and while the formal legal system is more civil law nature. And this comparison actually shows that the formal legal system in China is more rigid. It only depends on the legal rules written on the law. But by contrast, Xinfang system is more flexible and more dynamic. It consults law, state policies, social norms, and fair justice principles required by the constitution of the party. So this actually leads to the Xinfang system to have a more dynamic nature. It can evolve with the changing economic condition, can meet the demands of the changing social needs on private contracts, such as well as the property rights. Another distinction is that the formal legal system, which is commonly regarded as having a German civil law origin, was established by the end of Qing Dynasty, which is 1912, quite late. But the Xinfang system has always been there since 2000 years BC. So if research on China or Eastern countries that only focus on the formal legal system, I think they're missing the boat. So our hypothesis is that Xinfang system actually promotes financial markets by enforcing property rights, provides private contract, and also checks on government expropriations. And therefore, this increases the confidence of transactions on the market, therefore increases the financial market development. So the data description here is quite general. We have a more detailed data paper also by my supervisor and Rosalind in 2016 that we devote 60 pages to describe the data. It's a painful process to collect data. We spent like almost 2 years to do only the data section. We hand collect Xinfang regulations of each province during 1993 to 2014, which is our data sample period. We actually combine multiple sources, such as government officials' letters. We sent letters, about 500 letters to government officials. We spent like a month in the library to check provincial, local yearbooks to find the regulation and number. In total, we have obtained 60 regulations covering 27 provinces in our sample period. So after obtaining the Xinfang regulation, we code the Xinfang regulation based on 4 general areas. The first is the efficiency of dispute resolution, which is basically covering how long and how efficient a Xinfang bureau can resolve a Xinfang case. Some provinces require a Xinfang case has to be resolved within 15 days or 30 days, but others require 90 days or 120 days. So there's a huge variation among these dispute resolution time. The second area is the dispute resolution mechanisms. Different provinces have different mechanisms, and some have multiple channels to resolve disputes, but some only have limited channels. For example, one of the dispute resolution mechanism is actually for the Xinfang Bureau officials to go down to visit Xinfangers to resolve disputes. Other include video chat, Skype with the Xinfangers who file Xinfang cases. The third area is access support and restraints. Some of the provincial Xinfang bureaus actually restrain their access for the citizens to the Xinfang system because they regard the Xinfang cases as an element of social instability. And some of the provincial governments actually welcome citizens to file Xinfang cases because they show this is a way to get information from the citizens, also ensure social stability. So the last one is punishment and reward. Some provinces actually requires rewarding Xinfangers who file beneficial cases that had wide implication, wide influence, and while others do not. And also some provinces have like harsh punishment for those Xinfang workers who doesn't file cases when they should. So in particular, we focus 69 particular policies. These 69 are assigned to these the 4 areas mentioned previously. So we use these 8 measures to measure the. Is it opposite? But sorry. But these 8 measures are actually quite self-evident. They are widely used in the literature to measure the financial market development. Let me show the findings first. We found that Xinfang system actually promotes financial market development, and we show that a Xinfang finance nexus actually more pronounced in provinces with better legal institutions, because one common law, one civil law, they actually can complement each other, and the less corruption, because Xinfang actually draws power from the political system, from higher administration level. Therefore, less corruption means more power. And then we found that provinces with larger private economy also experience more pronounced relationship between Xinfang and finance, is because private economy doesn't have the protection from the state, so it actually should experience more pronounced effects from the Xinfang system. And we also find that in industries with larger size of non-current assets, which more subject to the risk of expropriation and more dependence on external finance, also experience more pronounced Xinfang finance relationship. In China, if you want to secure a loan, you have to have collateral. The collaterals often take the form of fixed assets and non-current assets. These assets are in nature more subject to risk of expropriation. So we also find that more dependence on external finance, the industry, the more pronounced relationship they experience. So at the firm level analysis, we also find that non-SOEs and non-political connected firms experience more benefits from the Xinfang system. As a result, they have more they can obtain more long-term debt and also make more long-term investments. So the contribution, we think we contribute law finance growth literature by providing a novel data set of legal system that is based on Eastern countries. We also relate to the research on China. We show that after taking into the alternative legal system into account, the law finance nexus actually applies to Eastern countries as well. So we also provide an explanation of long-standing puzzle that despite their weak legal institution, some Eastern countries can still grow at an enormous rate. We show that alternative legal institutions actually play a part in this process. While this research analysis is focused on China, we think that it may apply to many other Eastern countries. So that's it. Thank you.
Thanks a lot. Okay. Kaushik? And everybody else. So I'm opening the floor to questions because our discussant is not able to make it today. So questions from all of the floor, please. But Kaushik starts.
Thank you, Susan.
My pleasure.
So this seems like a pretty cool paper because just for me to know something more about the legal systems in China, whether they're formal or not, is useful. It's nice that you're able to tie this back into what we've learned from other countries and other jurisdictions, and that legal systems matter, whether they're informal or formal, and that this has been missed primarily because researchers that work on China don't know much about the system. I wish you had spent a little more time on your methodology because I would have liked to understand how you were doing some of these things. I was just looking through the paper. The one thing that I'm a little curious about is at one point you run an IB regression, and you have an incredibly strong first stage, which is great, and you have OLS estimates that are small, but then in your second stage, they get gigantic after the instrument. And typically, I mean, in most cases when you're running an IV regression, what the first stage is doing is it's absorbing a lot of the variation that's not clean and is just other stuff that's going on. So typically, the IV results are understated compared to the OLS results. And I'm surprised that you guys are finding such sort of the opposite thing. If that's really the way things work, that's amazing. There are very, very few IV papers that do that. But this is just something that I was curious about. I know this wasn't actually in the presentation, so if you don't want to talk about it now, that's fine. But those are my thoughts for now.
Okay. So should I reply now?
Please, go ahead.
The methodology, people most fire their ammunition on the IV instrument, right? Because it is subject to many problems. One of the problem we often get is that our IV actually is not a valid IV because it's associated with so many other things that may affect the Xinfang system, also the financial market system. So in our newest version of the paper, we actually dropped the IV. We use different differences in most of our analysis. But the IV, the problem you mentioned, I think is because in the first stage, I think the proxy for Xinfang system actually captures something else that negatively affects the financial development. Therefore, after the IV, which is quite relatively cleaner than the previous one in differences, therefore we can throw in a lot of fixed.
Is the def and diff that you're doing across regions? Because I saw
Yeah,
a map.
yes.
Okay, great. Yeah,
Yeah,
that's
across
exactly
regions.
what I would like to see.
Yeah.
Is because you have these different regions. And
Yes, yes.
But from your analysis, I didn't see you taking into account the change that
Yes.
would have happened in these institutions pre and post 2005,
Okay.
because I think that would affect your results quite a bit.
Okay, yeah.
The second point is, so again, from my limited understanding, and I could be completely wrong here, is the way it operates is the petitioners are essentially using the Xinfang organizations to basically go to the higher authorities.
Yeah.
And the higher authorities are then distributing the cases of resolution, dispute, etc. So, but it's also possible in often cases they are sending it back to the same local officials
Yes.
who did not address the case to begin with. And that would definitely affect the efficiency of the Xinfang institution to begin with. So that's something I would love to get your comments on. And the third point is, again, related to that second point, that it is in the interest of the local authorities to suppress the petitioners so that they don't send their dispute cases to the higher authorities, because otherwise the local authorities will end up looking bad. So there is some kind of this selection mechanism that's going on as to who can actually use the Xinfang institutions to reach these higher agencies. And actually I have a last point, which is, since it's an alternative legal system, is it possible, and that would actually worry me because it comes across as a rule of man, not a rule of law, that is it possible that the judicial or the court orders of the formal system can actually get reversed by the Xinfang system? So even if it's contributing or positively affecting financial development, I'm not sure to what extent from a desirability or rule of law perspective, that's essentially a great idea, but that's perhaps not the main point of your paper, but that's a more broad question.
Okay.
Thank you.
Thank you for those comments. That gave me the chance to explain more institutional background of the Xinfang system. The first one is in 1995 and 2005, there were two national Xinfang regulations, right? So as you said, there might be impacts on our analysis because they're national. They should apply to all of the provinces. The thing is, there's also National Xinfang Bureau which also resolve disputes. And those two regulations only actually applies to the National Xinfang Bureaus. Because the Xinfang regulation doesn't provide contents or basis to resolve disputes. It only provides a procedure. So those two National Xinfang regulations are procedures that applied to National Xinfang Bureaus. And on the province level, each province have their Xinfang regulation, their procedure to resolve their disputes. But that's a very good point. We also, in analysis, we actually control for this. We use a province times national. When they send back the case, they actually also send back a team that monitoring the case to resolve. So if the higher administrative level really devoted to resolve the case, they're going to make sure it's resolved. They're sending back a team that only also monitor and provide assistance for resolving the Xinfang regulation. So that somehow mitigates the concern a bit. Right? The third one is that local governments suppress the Xinfangers to file Xinfang cases. Yes, that's the case. Sometimes it suppresses it. But in China, at the modern stage, people can travel really, really at ease, right? If the local government doesn't want their citizens to file Xinfang cases at local level, they can surely go up higher. For example, a case happened in county level, let's say. So the Xinfangers, if the county government doesn't want the Xinfanger to file a case at the county government or county Xinfang Bureau, the citizen can go up higher to city level, to provincial level, and even the central government level. So there's no way that they can stop them to file the case. And the fourth one is that sometimes it is the case that the legal system, the legal case can be reversed by the Xinfang judgment. But this rarely happens. Sometimes it happens, but the amount of these kind of cases is really, really small. Most of the time is because the Xinfang system actually more independent and more fair than the legal system. Because if at the same level, the court, the legal system, the formal legal system are actually controlled by the government level. because they're appointing the officials of the local court. They can dismiss the officials of local court. They basically controls everything from the local court. So therefore, we can actually predict that the local court is more corrupt than the government, because actually it can it listens to the government whatever it says. But the Xinfang system actually seeks power from higher administration level. This level actually controls the local government. You see what I mean, right? So the Xinfang system is actually more fair and justice, and provide more justice and also more independent. So sometimes the legal cases are reversed by the Xinfang cases, but it is more like a good thing. Yeah. Thank you.
I have two comments. One, while this is informal, it still seems to be implemented or administered by the government. Okay. So to what extent should we really think of it as informal? Because there are several other papers that the community gets together and then there is an institution like that. So in that sense, is it really truly informal because the government is still there? And second, one of the things that might matter for financial development is the predictability of judgments. So it doesn't matter who is administering, as long as when a case is of a particular kind or a dispute is of a particular kind, you think that this is how it's going to evolve. So can you throw some light on the predictability of these institutions? Do they look at similar cases similarly?
So let me repeat the second question. You're asking whether these two systems resolve a case in a similar way.
Or even the informal system, okay. Is there a systematic pattern in which similar cases get resolved? Because then you can argue that it's the predictability that matters and not really whether it's formal or informal, however defined.
Okay. Let me first respond to the first question. We don't call the Xinfang system as informal. We call it alternative legal system. So it is not really informal because it's quite systematic and it's implemented at every level and in every provinces, and it's been there for I don't know how long. It's kind of traced back to 2,000 years before. It's always been there. For the second one, I'm not sure I got you, but I think you're asking the similar cases can be resolved in a similar way. Is it? Yes, it is. It is most time it can be resolved in a similar way. Because it depends on the. In fact, we can only suppose they're resolved in a similar way because we don't have the contents of the cases. We don't have the data. Although we try very hard, we didn't get the data.
So yeah. I guess what she's asking is that when you put up the difference between the legal systems, you said that the legal system actually follows the rule of law concept.
Yes.
Whereas this one actually includes a lot of society and community related.
Yes.
So the question that's probably what Renuka is asking is that because of all these alternative factors which are not just linked to rule of law, is it that in one type of property case, for instance, if it comes up, dispute resolution, a similar outcome is given every time. So if I have a property dispute of some type, I know that the outcome will be an award of this type. And so is there that predictability in this mechanism, or is it that a social factor can actually change the outcome in a same looking case? So for instance, France is a good example of this, where courts often overturn corporate disputes on considerations of labor related issues, right? And you could argue that that adds to the uncertainty of the outcome from the perspective of finance.
Yeah.
Is that kind of predictability available in this mechanism?
I think the answer is yes. Let me give you two examples. Whenever there's a violation of property rights, you can expect the results is always in favor of the victim who has been violated the property rights. And whenever it's a breach of contract, the Xinfang system always enforces the contract. So we don't find any other evidence that in one province this contract is breached, so it's ruled in favor of the victim. In other countries, it is not. It is not. We don't find that evidence. We find it's quite consistent.
But I have a short questions related to international business.
Okay.
So your case of as many as 500 and 600 cases include any international business case, in other words, dispute between residents and non-residents. That's question one.
Okay.
Question two is, what is the role of the Xinfang system in resolving dispute between resident and non-resident? In other words, when foreign multinationals want to come to China and they have dispute with local residents, local partners, and then the Xinfang system also works to resolve that issues. Third question is Xinfang system's role on opening up the Chinese financial market in global marketplaces.
Let me answer first two questions. The Xinfang regulation, on the Xinfang regulation, it officially states that this regulation applies to both foreigners and the local people. But in reality, we don't find any evidence or cases that involve a foreign party. You see? For the third question, I didn't quite get you. What did you mean by? Could you repeat the third question?
Okay. Any role of the Xinfang system in helping or contributing to opening up of Chinese financial market globally?
Opening up, no.
Thank you.
Yeah, I said I'm reminded of the film Godfather. So is it the case that there's some kind of self-selection of cases going on towards one particular system compared to the other one?
Could you repeat the question? I didn't.
Okay, so is it the case that there's self-selection of certain kind of disputes towards the two systems? Meaning, so certain kinds of disputes go to the Xinhua system and the others go to, like the formal legal system?
It is very difficult to answer because we actually don't have the data on the specific legal cases and specific Xinfang cases, so we can't actually match them. We can't actually see how do they select the system. But from a personal point of view, I think if I were the victim, I want to file cases, I would file in both systems, both the Xinfang system and the legal system. And in fact, most people, when they're using Xinfang system, they file their cases in different offices at the same time.